What single chapter of the Indian Constitution is so vital that the Supreme Court is legally bound to act as its ultimate defender and guarantor?
It's the bedrock, the absolute core.
We're talking about the bedrock of Indian democracy, fundamental rights. If you really want to understand the tension between state power and individual freedom in India, this is where you have to start.
It really is.
Today, we dive deep into Articles 12 to 35. They're legal articles, they're, philosophical roots, and the landmark judgments that make them the single most dynamic part of the polity syllabus.
And I'd say they're the engine room of liberty. These rights are not just historical assertions. They are constantly evolving legal promises that really define the modern Indian state. We're going to transform this dense material, mostly from Chapter 8 of Laxmikanth, into strategic insights.
And link the provisions directly to what the UPSC exams demand. Welcome to the Deep Dive, brought to you by Simplified UPSC by PPP. Our mission is clear: to take these essential, complex sources and distill them into clear, actionable knowledge tailored precisely for your preparation. We really want to give you that analytical edge.
Before we jump in, though, just a humble request from our side. If this deep dive helps you clarify these, complex concepts, please do consider supporting the work of Simplified UPSC by PPP.
You can do that by hitting the like button, sharing your valuable comments, and, this is the big one, subscribing and maybe even joining our paid membership on YouTube.
Your support honestly keeps us bringing this super useful, in-depth content to you.
And a massive shout out to all our existing members. Your belief in this mission helps us tremendously in sustaining this whole effort. We really do rely on you to keep the lights on and the analysis sharp.
Absolutely. And just one more thing on logistics, the notes. Free notes with practice PYQs are available on our Telegram channel.
And for our Legend YouTube members, the premium notes are on our Discord channel. Those have extra PYQs and even model mains answers. So, do join us there.
All right, let's get into it.
Let's unpack this. We begin at the foundation, Part 3 of the Constitution. Fundamental rights, or FRs, belong squarely to the philosophical core. So, where did this philosophy come from? How does it fit into the sort of global context of rights?
Well, the primary inspiration is very clearly the American Constitution, especially its Bill of Rights. FRs are essentially an assurance, to people that no matter who is in power, certain basic essential rights will be protected.
So they're a safeguard.
They're a safeguard against the state becoming despotic. They establish an area of individual liberty. They are, in essence, a charter of immunities against the state.
Okay, so the immediate strategic contrast for any serious student of polity is always between fundamental rights and DPSP, the Directive Principles of State Policy.
Always.
Beyond just being in different parts of the Constitution, what is the fundamental operational difference here?
The single most important word you have to remember is justiciability.
Justiciability, meaning you can actually go to court over them.
Precisely. Fundamental rights are justiciable. So if the state violates one of your FRs, you have the absolute legal right to seek a remedy from the judiciary, and you can even approach the Supreme Court directly.
But DPSPs are different.
DPFT, on the other hand, are non-justiciable. They are moral obligations on the state, guiding principles for policymaking, but you cannot go to court and compel the government to implement a DPSP.
So FRs are the tools of political democracy.
Right.
They restrict power, ensure immediate liberty, whereas DPSPs are aimed at building socioeconomic democracy, the long-term vision.
The long-term vision of a welfare state, yes. And that explains the constant tension we see in governance between the two.
It does.
And this distinction really emphasizes the nature of FRs as restrictions on the state's power. They are largely negative in character, saying what the state cannot do.
Like it can't discriminate or it can't restrict speech arbitrarily.
Exactly. They are prohibitions imposed on the government to protect that individual sphere.
But the moment we frame them as restrictions on the state, we have to qualify this because these rights are not, in fact, absolute. This is where the balance of the Indian system lies, isn't it?
That's a crucial insight. It's often tested in exams. And no, you're right, fundamental rights are not absolute. The state retains the power to impose reasonable restrictions on the exercise of nearly all of them.
Okay, give us an example.
Take the 6 freedoms under Article 19. Your freedom of speech can be restricted in the interest of public order, decency, morality, or the sovereignty and integrity of India.
So this power to restrict ensures that individual liberty doesn't just descend into social chaos or undermine the nation.
Yes, and the judiciary's role then becomes to determine if a restriction is truly reasonable. That's the key word.
Okay, let's move on to availability. When we say people have rights in India, Who are we talking about exactly? Are foreigners and corporations covered?
This needs careful categorization. Some rights are granted exclusively to citizens.
Which ones are those?
These include the cornerstone freedoms in Article 19 speech, assembly, association, movement, residence, profession, and also the rights against discrimination in Article 15 and equality in public employment in Article 16.
But some of the most critical protections extend beyond citizens.
Yes, the ones focused on due process and life, they extend to all persons, which includes foreigners and even legal persons like corporations.
So which specific articles apply to all persons?
The big ones. Protection in respect of conviction for offenses, that's Article 20. Protection of life and personal liberty, the famous Article 21. And the right to constitutional remedies under Article 32. These are core examples that apply universally.
So the idea is that foundational human rights are guaranteed regardless of citizenship.
That's the principle.
Now, you said FRs traditionally protect us from the state, but you mentioned an exception where rights protect an individual even against private actors. This feels like a vital nuance, especially given India's social history.
It's a huge exception. It's found in Article 15.2. While most FRs are a check on the government, Article 15.2 prohibits discrimination based on religion, race, caste, sex, or place of birth, even by private individuals, regarding access to public facilities.
Public facilities like what?
Shops, public restaurants, hotels, and the use of wells, tanks, bathing ghats, roads, and places of public resort that are maintained wholly or partly by state funds.
So this provision directly targets things like social untouchability and private discrimination in the public sphere.
It gives the FRs a powerful vertical reach, yes. It's a direct tool for social reform.
That significantly broadens the scope of equality. Okay, let's turn our attention to the defender of these rights, the Supreme Court. Why is Article 32, the right to constitutional remedies, considered so extraordinary? Why is it a fundamental right in itself?
Well, Article 32, which Dr. B.R. Ambedkar called the heart and soul of the Constitution, is the ultimate safeguard.
The heart and soul.
Because the right to petition the Supreme Court for the enforcement of FRs is itself a fundamental right. This means the Supreme Court cannot refuse to hear a petition when an FR is violated. The remedy is mandatory.
So that automatically makes the Supreme Court the defender and guarantor of all the other fundamental rights.
It does. Without Article 32, the FRs would be, well, mere declarations of intent. They wouldn't have any teeth.
This mandatory nature leads to a really critical technical distinction, one that's often confused. The difference in writ jurisdiction between the Supreme Court under Article 32 and the High Courts under Article 226.
Yes, this is a nuanced area, but it's strategically important for the exams.
So can you break down the weight of Article 32 versus the wider scope of Article 226?
Okay. The Supreme Court, under Article 32, can only issue writs for the enforcement of fundamental rights. That's its scope. But the moment an FR violation is established, the remedy is mandatory. The court has to act.
And the High Court?
The High Court, under Article 226, has a much wider scope. It can issue writs not just for fundamental rights, but also for the enforcement of ordinary legal rights.
So if your contract is breached or some local rule is violated, you'd go to the High Court.
That's right. This makes the High Court's scope wider in terms of the subject matter it can address.
So the High Court can technically address more issues, but its power is discretionary, whereas the Supreme Court's under 32 is limited to FRs, but mandatory.
Exactly that. The High Court may refuse to exercise its jurisdiction under 226. It's a choice.
Yeah.
But the SC must grant a remedy under 32 if the petition relates to a fundamental right. So the High Court is institutionally wider, but the SC's power regarding FRs is institutionally superior. It's non-negotiable.
Got it. And a quick historical placement. These tools of enforcement, the 5 writs habeas corpus, mandamus, prohibition, certiorari, and quo warranto, where do they come from?
They're borrowed directly from the English legal system. Historically, they were known as the prerogative writs. They are powerful administrative tools used by superior courts to control inferior courts, tribunals, and public authorities, ensuring legality and due process.
So they're instruments for checking governmental overreach.
Fundamentally, yes.
Let's move into the practical application, starting with the first pillar. Equality, Articles 14 through 18. Article 14 sets the overarching stage with 2 core concepts.
Right. Article 14 guarantees 2 things: equality before the law and equal protection of the laws.
What's the difference?
Equality before the law is a negative concept rooted in British tradition. It's about the rule of law. It implies that no person, regardless of their rank or position, is above the law. Everyone is equally subject to the ordinary law of the land.
And equal protection of the laws is the positive side of that coin.
Yes. That concept, borrowed from the U.S. Constitution, is more proactive. It means equals must be treated equally. But it also means different treatment is permissible if there's a reasonable classification.
A reasonable classification.
Yes, it must be based on an intelligible differentia. And that differentia must have a rational relation to the objective of the law. So you can classify groups, for instance, tax laws can treat corporations differently from individuals, and that classification can't be arbitrary, it must be based on reason.
This leads us directly into Article 15, which prohibits discrimination on 5 grounds. Religion, race, caste, sex, or place of birth. We already mentioned that 15.2 is unique because it binds private individuals.
Exactly. And the dynamics of Article 15 have been radically reshaped in recent decades by exceptions carved out to achieve what we call substantive equality. The state is allowed to make special provisions for women, children, and for the advancement of socially and educationally backward classes, or for SCs and STs.
And the most recent and strategically significant addition here is the 103rd Amendment of 2019, introducing the quota for economically weaker sections, or EWS.
This is a landmark shift, absolutely. The 103rd Amendment allows the state to make special provisions and a reservation of up to 10% for EWS in admission to educational institutions.
And the Supreme Court upheld this.
It did. The court confirmed that reservation based solely on economic criteria does not violate the basic structure of the Constitution. What's crucial for UPSC aspirants is noting the specific exclusion. This reservation does not apply to minority educational institutions.
Which reflects the protections they get under Article 30.
Precisely.
That economic criteria link is critical, and it brings us to Article 16, equality of opportunity in public employment. This is really the battleground for reservation policy.
It is. Article 16 guarantees equality of opportunity for all citizens in matters of employment or appointment to any office under the state. It also prohibits discrimination on the same grounds as Article 15, but it adds dissent and residence to the prohibited list.
The history of reservation policy here is just inextricably linked to the 1992 Indrasani case, the Mandel judgment. The complexity of implementing this often shows up in Maine's questions. What did that judgment mandate for OBCs?
The Indrasani judgment was revolutionary. It upheld the 27% reservation for OBCs announced by the government. But it also said that reservation cannot exceed a 50% ceiling, barring exceptional circumstances. And crucially, the court mandated the exclusion of the creamy layer.
The creamy layer.
Meaning the socially and economically advanced persons among the OBCs must be excluded from reservation benefits to ensure that the truly needy actually benefit.
Wait, if the ruling mandated the creamy layer exclusion, why is the state still struggling so much to define and implement it fairly? And how would that complexity show up in a UPSC mains answer?
That's where the strategic insight lies. The struggle isn't about the legal definition, which exists, but about administrative feasibility and, frankly, political will.
It's just hard to implement.
It's inherently complex. It forces the state to make fine distinctions based on income, property, and status within a defined backward class. This leads to constant litigation and bureaucratic pushback. So for a mains answer, you need to highlight that the creamy layer concept is designed to maintain the whole point of reservation distributive justice, but its difficult implementation is a major governance challenge that dilutes the policy's effectiveness.
And we also need to remember the 103rd Amendment brought the 10% EWS quota into Article 16 as well.
Yes, extending that reservation to civil posts and services.
Okay, let's turn to the rights to freedom, Articles 19 through 22. Article 19 is the Charter of Individual Liberties. We know the right to property was deleted from here by the 44th Amendment in 1978. What are the 6 remaining freedoms, and why is that restriction clause so vital?
The 6 freedoms are speech and expression, assembly peaceful and without arms, association, movement, residence, and profession or occupation. And as we said, they are only for citizens. The restriction power is vital because these rights exist in a social context. The state can impose reasonable restrictions based on grounds listed within the article itself.
For instance, freedom of expression is restricted for grounds like defamation or contempt of court, but freedom of association can be restricted in the interest of public order or morality. This shows that constant negotiation required for democracy.
Exactly. And the Supreme Court often has to step in to balance those competing interests. For example, regarding public order, the state has to demonstrate that the restriction on assembly or movement is proportionate and necessary to prevent serious disorder, not just some minor inconvenience.
Right. Moving to Article 20, protection against conviction for offenses. This is a crucial right, applicable to all persons. What are the three non-negotiable protections here?
These are safeguards against arbitrary punitive state power. 1, no ex post facto law. You can't be penalized for an act that wasn't illegal when you did it.
2, no double jeopardy.
Meaning you can't be prosecuted and punished for the same offense more than once, though an acquittal doesn't bar a departmental inquiry, just another criminal prosecution. And 3, no self-incrimination. No accused person shall be compelled to be a witness against himself.
But that only applies to testimony, right? Not physical evidence.
Correct. Compulsory production of material evidence like fingerprints or blood samples is permitted.
Now here's where we see the most dramatic judicial action. Article 21, the right to life and personal liberty. Before 1978, Article 21 was nearly toothless. Can you explain how one bad judgment, A.K. Gopalan in 1950, restricted freedom for nearly 3 decades?
The Gopalan case was the nadir of liberty interpretation. The court adopted a very literal, textualist approach to the phrase procedure established by law. They ruled that if Parliament passed any law establishing a procedure for depriving someone of life or liberty, even if that law was draconian or unfair, the courts couldn't question it.
So the protection was only against arbitrary executive action, assuming the law was followed.
Yes. It was a direct rejection of the American concept of due process of law, which allows courts to test the fairness and reasonableness of the law itself.
So if Parliament established a terribly unjust procedure by law, the courts were legally bound to say, well, the procedure was followed, so it's valid. That's a massive restriction on liberty.
It left citizens completely vulnerable to arbitrary legislation. But then the judicial landscape fundamentally shifted with the Menaka Gandhi case in 1978.
Which overruled Gopalan.
Completely. The Supreme Court mandated that the procedure established by law must be fair, just, and reasonable. This effectively introduced due process, so protection is now available against arbitrary legislative action as well. Any law must now satisfy the triple test of Articles 14, 19, and 21. If a procedure is arbitrary, it violates Article 21.
This shift from a narrow, literal reading to a broader due process interpretation, it just transformed Article 21 into the single most important reservoir of rights.
It did. The Supreme Court has since used this expansive reading to declare a huge catalog of implied rights under Article 21.
What are some of the most critical ones that weren't explicitly listed in the Constitution?
Oh, the list is massive. It reflects the judiciary's active role in shaping what a dignified life means. We have to include the right to live with human dignity, which is more than just animal existence.
Then there's the environment.
A crucial one for governance. The right to a decent environment, including pollution-free water and air, protection against hazardous industries. The courts have actively shut down or relocated polluting industries under this right.
And others.
The right to livelihood, the right to privacy, which we'll come back to with the Puddaswamy case, the right to shelter, health, free legal aid.
And, of course, the right to free education up to 14 years of age, which later got formalized as Article 21A.
A fundamental right in itself. In that one case, Paschimembanga Ketmasdor-Samity in 1996, about the right to timely medical treatment, is such a powerful example of the judiciary actively shaping state infrastructure.
Tell us about that one.
Well, that case established that providing timely medical treatment in a government hospital is an integral part of the right to life. When a person was refused admission by multiple hospitals after an accident, the Supreme Court ruled that a government hospital cannot refuse treatment in emergencies.
So it effectively mandated adequate health infrastructure and responsiveness under Article 21.
It's judicial activism enforcing government duties, a classic example.
Finally, in this section, Article 22, protection against detention. The unique aspect here globally is India's constitutional inclusion of preventive detention.
That's right. Preventive detention allows the state to detain a person without trial, based merely on a suspicion that they might commit an offense in the future.
It's an extraordinary power.
It is, and the Constitution tries to balance it with some safeguards. The detainee must be informed of the grounds, allowed to make representations, and the detention generally can't exceed 3 months unless an advisory board confirms there's sufficient cause.
And this power is exercised through specific acts like the UAPA, the Unlawful Activities Prevention Act.
Yes, and the very existence of this power is a continuous source of debate about individual liberty versus state security. It's a profound check on liberty, justified by constitutional necessity, but it really sets India apart from many Western liberal democracies.
Okay, let's move forward to the social justice rights. Articles 23 and 24, the right against exploitation. Article 23 seems to target historical forms of coercion.
It's very comprehensive. It prohibits three things: human trafficking, big R, which is forced labor without payment, and other similar forms of forced labor.
And traffic in human beings is interpreted broadly.
Very broadly. It includes the sale and purchase of people, particularly women and children, for immoral purposes. Critically, this protection is available against both the state and private individuals.
Is there any exception?
Just one. The state can impose compulsory service for public purposes, like military service during a war.
And Article 24 deals specifically with the protection of children.
Yes. Article 24 prohibits the employment of children below the age of 14 in any factory, mine, or other hazardous employment. It's a direct measure to ensure dignity and education for children.
And what's crucial here is the Supreme Court's proactive intervention in 1996 to give this article some real teeth.
You're referring to the establishment of the welfare fund. That's right. The 1996 Supreme Court directive mandated that any employer violating Article 24 has to pay a fine of $20,000 for each child they employ.
And that money goes into the Child Labor Rehabilitation Welfare Fund.
Exactly. And beyond the fine, the court directed the state to provide continuous surveillance, health, education, and nutritional improvements for the children rescued. It converted a negative prohibition into a positive mandate for state action and rehabilitation.
It's a clear governance signal, but it also highlights how deep the problem runs, needing that kind of judicial intervention.
It really does.
Next up, the complex but essential right to freedom of religion, Articles 25 through 28, which really underpins India's unique brand of secularism. Article 25 covers individual freedom.
Right. Article 25 guarantees every individual the freedom of conscience and the right to freely profess, practice, and propagate their religion.
So what do those terms mean in practice?
To profess is to display one's beliefs publicly. To practice is to perform rituals and worship, and to propagate is to disseminate one's faith. However, this right is always subject to public order, morality, and health.
And the state can still regulate secular activities associated with religion.
It can. It retains the power to regulate any economic, financial, political, or other secular activity, which allows for reforms in things like temple entry or marriage laws.
Okay, and Article 26 covers the institutional rights, the right of religious denominations to manage their own affairs.
That's the distinction. 25 is for the individual, 26 is for the institution, the right of a religious institution to manage its temple or mosque property. Both are protected, but the institutional right is more focused on autonomy in religious management.
Let's focus on the distinction made in Article 28 about religious instruction in educational institutions. This is very nuanced based on where the money comes from.
It is. The rules are designed to balance state neutrality with respecting religious trusts. There are 4 distinct categories.
Okay, what's the first?
First, institutions wholly maintained by the state. These are fully government-funded. They cannot impart any religious instruction whatsoever. The state must be completely secular here.
And the second?
Institutions administered by the state, but established under a trust or endowment. If a trust mandated religious instruction, it is permitted, even if the state is now administering it.
So that respects the original intent of the trust.
Exactly. Third, institutions recognized by the state. If the institution is only recognized but not aided, religious instruction can be given, but attendance has to be voluntary.
And the fourth must be state-aided.
Right. Institutions receiving aid from the state. Similar to recognized status, if it gets state aid, religious instruction is permitted, but attendance must be voluntary and requires the consent of the student or their guardian.
That clarity on the 4 types is vital for students to lock in. It really tests the subtle relationship between government funding and the secular mandate. Now let's talk cultural and educational rights for minorities, Articles 29 and 30.
Article 29 protects the interests of minorities in 2 main ways. First, any section of citizens with a distinct language, script, or culture has the right to conserve it. This is a foundational protection for cultural identity.
And the second part?
Second, it prevents the denial of admission into any state-maintained or state-aided educational institution solely on the grounds of religion, race, caste, or language.
And Article 30 provides the institutional right for those minorities.
Article 30 is the institutional counterpart, yes. It grants all religious and linguistic minorities the fundamental right to establish and administer educational institutions of their choice. This right ensures the self-preservation of their identity and culture through education.
And the state can't discriminate in giving aid.
Exactly. That's to ensure the right isn't diluted by financial pressure.
Okay, let's move on to the crucial saving laws. The clauses that protect certain legislation from being challenged under fundamental rights. I'm talking about Articles 31A and 31C. Historically, these were absolutely necessary, weren't they?
Absolutely. The tension between the desire for social reform, particularly land reform, and the fundamental right to property was explosive right after independence.
So what did Article 31A do?
Article 31A saves 5 categories of laws, primarily those concerning the acquisition of estates or land reforms, from judicial review based on a violation of Article 14, equality, and Article 19, freedoms. The goal was to provide constitutional insulation for policies aimed at dismantling feudal structures.
And Article 31C elevates certain DPSP provisions, creating a protective shield for them against Articles 14 and 19.
Yes. Article 31C was introduced to protect laws enacted to implement the socialist principles specified in Article 39B and C.
Those relate to equitable distribution of resources and preventing concentration of wealth.
Right. So if a law aims to achieve those specific DPSP goals, it can't be declared void just because it infringes on Articles 14 or 19.
But didn't the Supreme Court step in here to prevent DPSPs from completely swallowing fundamental rights? This is where the basic structure doctrine comes back in.
The Minerva Mills case of 1980 is the resolution. While 31C tried to grant unlimited precedence to DPSPs over Articles 14 and 19, the Supreme Court struck down that unrestricted power.
So what did they say?
The court confirmed that the balance and harmony between fundamental rights and the directive principles of state policy is itself a part of the basic structure of the Constitution. Therefore, Parliament can't amend the Constitution in a way that destroys this fundamental harmony.
Which ensures that FRs remain the minimum guaranteed floor of liberty.
Precisely.
And briefly, let's just touch on Parliament's power to restrict FRs under special circumstances, like for security forces.
Right. Article 33 gives Parliament the power to modify or even abrogate the application of fundamental rights to members of the armed forces, paramilitary forces, police, and intelligence organizations. This is done to ensure the proper discharge of their duties and maintain discipline.
And Article 34?
Article 34 deals with indemnifying acts done during the operation of martial law. It lets Parliament retroactively validate actions taken by any person to maintain order during martial law, even if those actions temporarily violated FRs.
This final section is where we synthesize all these legal doctrines into actionable strategic knowledge for governance and the UPSC exam. We have to start with Article 13, the foundation of judicial review and the doctrine of severability.
Article 13 is the sword of the judiciary. It states unequivocally that any law that is inconsistent with or violates fundamental rights shall be void.
But the doctrine of severability dictates how that law is void. Yeah. It's not always the whole thing, is it?
No, it's void only to the extent of its inconsistency. If the invalid portion can be surgically removed without destroying the integrity or objective of the remaining law, then only that offensive part is struck down.
And the classic example you mentioned earlier, A.K. Gopalan, illustrates this perfectly.
It does. The court upheld the Preventive Detention Act generally, so the whole law wasn't struck down. But they specifically severed and struck down Section 14 of the Act, which required the court to keep communications about the detention confidential.
Because that section violated Article 22.
Exactly. But the rest of the detention mechanism remained valid. It's judicial precision at work, avoiding legislative destruction where possible.
The ultimate check on Parliament's power, however, remains the basic structure doctrine. This doctrine emerged from the sheer necessity of limiting legislative enthusiasm, didn't it?
It did. The Kesavananda Bharati case of 1973 is the magnum opus of Indian constitutional law. It established that Parliament, while it has the power to amend the Constitution under Article 368, cannot use that power to alter or destroy the basic structure or basic features of the Constitution.
This was a direct response to aggressive amendments that sought to weaken fundamental rights in judicial review.
It was.
So what were the practical implications? What core features were deemed untouchable?
Well, the list isn't exhaustive, but elements like the supremacy of the Constitution, the Republican and Democratic form of government, the secular character of the Constitution, the independence of the judicial review, and the essential features of fundamental rights themselves were recognized as part of the basic structure.
So this doctrine ensures that even a massive legislative majority can't just dismantle the democratic foundation upon which all these rights are built.
That's the idea.
Let's turn now to judicial evolution and the modern expansion of rights. This shows how the judiciary really acts as the dynamic conscience of the republic. The evolution of capital punishment is a fascinating story linked directly to Article 21.
The Bhakan Singh case in 1980 is essential here. It confirmed that the death penalty itself was constitutional, but to satisfy the fair, just, and reasonable procedure demanded by Article 21, it had to be used sparingly.
So the court confined it to the rarest of rare cases.
Yes, where the alternative option of life imprisonment is unquestionably foreclosed. This judgment essentially raised the bar for procedural fairness and proportionality in the gravest state action possible.
Two incredibly powerful recent rulings cemented modern social rights: the right to privacy and the fight against discrimination based on sexual orientation. Let's start with privacy. How did Puttaswamy in 2017 resolve decades of conflict?
Before Puttaswamy, the judiciary had conflicting rulings on privacy. But Puttaswamy finally and decisively affirmed that the right to privacy is a fundamental right, inherent in the dignity of the individual and protected under Article 21.
This was critical in the context of Aadhaar and increasing state surveillance.
Absolutely. The ruling established that any invasion of privacy must satisfy 3 criteria. Legality, it has to be backed by law necessity for a legitimate state aim, and proportionality. This gave citizens a powerful check against government overreach in the digital age.
And following that was the historic Navtej Singh Johar case, which redefined dignity and equality for the LGBTQ+ community.
That 2018 judgment decriminalized consensual homosexual acts by partly reading down Section 377 of the IPC. But the court didn't just strike down a law, it delivered a profound lesson on the interconnectedness of fundamental rights.
So how did it connect them?
It emphasized that Section 377 violated rights under Article 14 for equality, Article 15 for non-discrimination, Article 19 for freedom of expression of identity, and of course Article 21, the right to live a life of dignity, self-determination, and privacy. It was a judicial recognition that constitutional morality must prevail over societal prejudice.
Cementing the idea of dignity for all citizens.
For all.
Finally, let's tie these abstract concepts back to governance and the UPSC perspective. Let's link fundamental rights to broader challenges, like land reforms and internal security. Let's start with land reforms and economic equality.
Okay, so when you're answering a mains question about the relationship between land reforms, agricultural productivity, and poverty, the constitutional journey is your key insight. The initial necessity to exempt land reform laws through Articles 31A and 31B was a constitutional realization.
A realization that certain individual FRs, like property rights, had to be tempered.
Tempered temporarily, yes, to achieve the grander constitutional goal of socioeconomic justice promised in the preamble and the DPSP, specifically Article 39B and C.
So the strategic point for an answer is that restricting property rights was not an anti-liberty act, but a pro-welfare state necessity.
Precisely. The state needed to break the feudal structure, redistribute resources equitably, and ensure wealth didn't concentrate to the common detriment. By protecting land reform laws from Article 14 and 19 challenges, the Constitution allowed the state to prioritize the collective good over individual property holdings. This enabled the transition to a welfare state model.
So that constitutional battleground is central to India's economic history.
It is.
Okay, let's look at a contemporary and highly critical national security link: tribal rights and extremism. Our source material links the non-implementation of Fifth Schedule provisions to the rise of left-wing extremism. How does a failure in governance regarding tribal administration link back to FRs and DPSP?
This is a complex but crucial link for governance questions. The failure stems from constitutional negligence regarding DPSP Article 46, which mandates the promotion of educational and economic interests of scheduled castes and tribes.
And the Fifth Schedule provisions are the tools to achieve that goal.
They are. They're meant to provide special administrative structures to protect tribal land, resources, and traditional governance, thereby fulfilling that DPSP.
So when the state fails to effectively implement the protective mechanisms of the Fifth Schedule, say, by allowing mining without proper compensation or facilitating land alienation, what's the constitutional fallout?
The fallout is the erosion of fundamental rights. That lack of protection translates into the denial of the right to livelihood and the right to live with dignity, both of which are now covered under the expanded Article 21.
So when tribal populations are displaced without adequate rehabilitation, they become alienated from the state.
Yes, and this creates a governance vacuum where the state has failed its basic constitutional duty under Article 46. This deep-seated frustration over resource deprivation and administrative neglect provides fertile ground for anti-state extremist ideologies like LWE to flourish.
It's a powerful lesson. Governance failures in areas like DPSP and special schedules inevitably translate into profound violations of fundamental rights, leading directly to issues of national security. This entire deep dive shows that the fundamental rights are not some static legal document.
Not at all. They are a living, breathing, constantly negotiated commitment to individual dignity. And that negotiation, led by the Supreme Court, is why mastering these articles and their associated case laws, the cases are as important as the articles themselves, is absolutely non-negotiable for UPSC success.
They really represent the battleground where the state and the individual constantly negotiate their legitimate positions.
That's the perfect way to put it.
We've covered a massive amount of ground from the core chapters of Laxmikanth's Polity, providing a full strategic summary for your targeted preparation.
And before we leave you, a final reminder. If this deep dive helped clarify these complex concepts for you, please support the work of Simplified UPSC by PPP.
You can do that by hitting that like button, sharing your valuable comments, and subscribing, or even joining our paid membership on YouTube.
Your support enabled us to keep these super useful resources coming to you.
And don't forget, you can find our free notes and practice previous year questions on our Telegram channel. For the comprehensive preparation, our premium notes with extra PYQs and model mains answers are available on our Discord channel for our Legend YouTube members. Do join us there.
Now here's a provocative thought for you to carry forward as you continue your study of Article 21. We've discussed how the right to life has expanded to include everything from clean air to privacy.
But the Indian justice system faces massive backlogs. Cases often take years to resolve. The right to speedy justice, while implied by the judiciary, is often severely compromised in reality.
So think about this. Should the right to adjudication within a maximum period of 1 year, as has been recommended by various judicial and parliamentary commissions, be elevated from just a judicial goal to a formally guaranteed fundamental right under Article 21?
That would effectively make legal and procedural efficiency a non-negotiable element of personal liberty. It would force the state to allocate resources and adopt reforms to guarantee timely justice.
A question worth pondering deeply, as the efficacy of all other rights, whether political or economic, relies entirely on the timely machinery of justice. Thank you for joining the deep dive.